Before we begin, a quick and important disclaimer. The following presentation is a comprehensive historical and sociological analysis focusing on the evolution of family law and the role of the divorce attorney within the context of American legal academia. This content is provided strictly for educational, informational, and historical study purposes only. It does not constitute legal, financial, marital, or professional advice of any kind. I am acting as a historical researcher charting the academic development of legal doctrines, not as a practicing attorney offering counsel. The historical trends, academic theories, and past case studies discussed in this masterclass reflect the societal and legislative frameworks of their respective eras and do not represent guaranteed legal outcomes or current statutory guidelines in any specific jurisdiction. Family law is deeply complex, constantly evolving, and varies drastically from state to state and county to county. If you are currently navigating a domestic legal dispute, considering a change to your marital status, or seeking to understand your specific legal rights and obligations, you must independently conduct your own due diligence and consult with a licensed, qualified legal professional who can evaluate the exact particulars of your individual situation. Do not use this historical academic analysis as a substitute for competent legal representation. Imagine stepping into the suffocatingly silent, oak-paneled lecture halls of a prestigious American Ivy League law school in the year 1895. The air is thick with the smoke of pipe tobacco and the absolute certainty of structural tradition. At the front of the room, a formidable professor is forcefully dissecting the nuances of property law, corporate contracts, and intricate torts using the newly minted and highly rigorous casebook method. These are the exalted subjects of legal academia, the arenas where brilliant young minds are forged to become the architects of American industry and governance. But if a student were to raise their hand and ask about the legal mechanisms of marital dissolution, the room would fall into a chilling, uncomfortable silence. In the late 19th and early 20th centuries, the concept of the divorce attorney was viewed by the elite echelons of American academia not as a subject worthy of rigorous scholarly pursuit, but as a sordid, undignified, and morally compromised necessity of the lower courts. The scholars of the ivory tower looked down upon the practice of domestic relations with active disdain. To be a divorce attorney during this era was to be relegated to the absolute margins of the legal profession, often stereotyped as an opportunist feeding off the moral decay of the private sphere, dealing in scandalous accusations of adultery, cruelty, and abandonment required by the strict fault-based divorce laws of the time. Yet, beneath this heavy shroud of academic stigmatization, a quiet and highly subversive revolution was beginning to take root in the most unlikely of places. While the academic elites focused on railroad trusts and maritime law, a rogue faction of legal scholars, sociologists, and fiercely independent thinkers began to realize a terrifying truth. The very foundation of the American Republic was not the corporation, but the family unit, and the legal framework governing that unit was hopelessly archaic, chaotic, and fundamentally broken. They recognized that the explosive growth of the American city, the shifting economic realities of the Industrial Revolution, and the changing roles of individuals within the household were creating a massive collision course with 18th-century marital laws. The divorce rate, which had hovered at a mere fraction of a percent for decades, was slowly beginning its relentless upward climb, creating a crisis in the local courts that academia could no longer afford to ignore. This is the untold story of how a deeply stigmatized profession systematically fought its way into the highest realms of intellectual legitimacy. We are going to examine the fascinating historical trends that forced the most rigid academic institutions in the United States to not only acknowledge the divorce attorney, but to actively begin designing the modern infrastructure of family law. We will explore the critical turning points from the introduction of sociological jurisprudence, which argued that the law must adapt to human realities rather than abstract moral theories, to the pivotal mid-century academic battles that eventually birthed the concept of no-fault divorce. The profound shift did not happen overnight, and it did not happen in the courtrooms first. It was meticulously engineered over decades of fierce intellectual warfare within the law reviews and faculty lounges of American universities. The individuals who championed this shift were initially pariahs, risking their academic tenure and professional reputations to argue that the dissolution of a marriage required just as much legal sophistication, economic analysis, and psychological understanding as the dissolution of a multi-million-dollar corporate merger. This deep dive masterclass will reveal the profound historical paradox of the American divorce attorney, how a role once considered the absolute gutter of the legal profession transformed into a massive multi-billion-dollar industry, backed by the most rigorous academic scholarship in the world. We will analyze the landmark publications, the pivotal legal clinics, and the specific academic pioneers who realized that to change society, they first had to change how the law was taught to the next generation of judges and legislators. You will discover the invisible academic architecture that dictates the contemporary realities of alimony, child custody presumptions, and the division of marital assets. For the modern American viewer, understanding this hidden academic history is absolutely critical. The legal contracts that govern your personal life, the societal expectations placed upon your domestic partnerships, and the incredibly complex systems you would face should those partnerships dissolve are not random forces of nature. They are the direct result of historical academic design. By tracing the evolution of the divorce attorney from an academic outcast to a central figure in American jurisprudence, you will gain a profound understanding of how legal systems adapt to, and often attempt to control, human behavior. You will learn how theoretical debates in university classrooms translated into the harsh realities of the courtroom floor, fundamentally altering the socio-economic trajectory of millions of American families. This is not merely a study of past events. It is an examination of the precise historical machinery that built the modern American domestic reality. We are going straight to the academic ground zero of the modern family law system, dissecting the historical case studies and the brilliant, controversial minds that decided exactly how the state should intervene when love fails and the contract is broken. To understand how this massive intervention in the private lives of citizens was designed, we must first examine the rigid architecture of the late 19th century American law school. During this period, the legal curriculum underwent a massive transformation championed by scholars who sought to elevate the law from a mere trade, learned through apprenticeship, into a pure, rigorous science. They pioneered the casebook method, treating appellate court decisions like biological specimens to be analyzed in a sterile laboratory. In this pristine academic environment, corporate contracts were predictable. Property deeds and land trusts were mathematical and logical. Torts and liability had clear chains of causation. But a failing marriage presented a horrifying anomaly to these academic purists. A failing marriage was an unpredictable, chaotic disaster of human emotion, completely lacking the scientific rigor that the elite universities demanded. Therefore, domestic relations were systematically excluded from the core curriculum of the nation's top institutions. If you were an ambitious law student in the year 1895, you were meticulously groomed to draft railroad charters and manage industrial monopolies, not to divide household assets or mediate the custody of children. The academic elite built a massive, invisible wall around the subject, decreeing that family disputes belonged to the church, the local community, or the lowest municipal courts, but certainly not the hallowed halls of legal science. Imagine, if you will, a standard American family living in a major Eastern industrial hub during the early 20th century. Let us consider a hypothetical citizen named Arthur and his wife attempting to dissolve their union. They could not simply cite irreconcilable differences, a modern legal concept that was completely non-existent and philosophically offensive to the lawmakers of the time. They were trapped in a system built entirely on the absolute concept of fault. To secure a divorce, Arthur or his wife had to publicly prove, on the official permanent court record, that the other spouse had committed a grievous moral offense, specifically adultery, extreme physical cruelty, or total marital desertion. This rigid framework created a profound and highly corrupt legal paradox. If both parties recognized the marriage was deeply broken and actually mutually desired the divorce, they often had to manufacture a crime to satisfy the state statutes. They had to engage in strict legal collusion. This involved hiring a very specific type of local lawyer willing to orchestrate a theatrical farce. This attorney would arrange for a staged adultery scene in a boarding house, hire professional witnesses to testify to the manufactured infidelity, and present this carefully rehearsed perjury to a municipal judge. The judge usually knew exactly what was happening but was bound by the rigid, archaic statutes to accept the unquestioned testimony. The lawyers who orchestrated these daily performances in the local courts were the original American divorce attorneys. Because of the inherent deceit required by the fault-based system, these practitioners were widely considered the absolute bottom feeders of the legal ecosystem. They were the fixers and the scandal-mongers, handling the unmentionable, unsavory business that the prestigious corporate law firms categorically refused to touch. They operated entirely outside the respectable boundaries of academic legal theory, dealing in cash, hushed hallway negotiations, and manufactured outrage. Looking back from our modern vantage point in the year 2026, where family law is an incredibly sophisticated, multi-billion-dollar legal sector requiring deep expertise in tax liability, forensic accounting, and complex interstate jurisdictional statutes, the historical disdain for the divorce practitioner is almost unrecognizable. Today, the dissolution of a high-net-worth household can easily rival a corporate merger in its sheer financial and logistical complexity. Yet, for decades, the academic establishment actively ignored this growing reality. By looking the other way, the universities allowed a massive parallel legal system to flourish completely unchecked in the shadows of the American justice system. The local municipal courts were drowning in a rapidly rising tide of domestic dissolution, fueled by the rapid urbanization of the country, shifting economic realities for women entering the workforce, and the massive social upheavals following the First World War. This environment created deeply concerning historical trends in legal geography. The phenomenon of the divorce mill became a national scandal. Wealthy individuals who could afford to travel began utilizing geographical arbitrage to escape the strict laws of states like New York or South Carolina. They boarded trains to territories like the Dakotas or later Reno, Nevada, establishing brief, superficial residencies solely to take advantage of highly permissive local divorce statutes. This created a blatant two-tiered justice system. The wealthy could buy their way out of a broken marriage through interstate travel, while the working class was forced into the degrading, perjured theater of the local fault-based courts. Academia watched this geographical legal chaos unfold in absolute horror. The glaring disconnect between the pristine legal theories taught in the Ivy League and the messy, perjury-filled reality of the actual courtrooms became a profound crisis of institutional legitimacy. The justice system was being made a public mockery, and the academic elites finally realized they could no longer pretend the problem did not exist. The turning point required a massive foundational paradigm shift in how the law itself was conceptualized by scholars. It required the destruction of the old scientific formalism and the birth of a radical new academic philosophy, known as sociological jurisprudence. The pioneering champions of this movement argued a profoundly controversial idea for the time. They proposed that the law is not a sacred, unchanging set of scientific principles handed down from antiquity, but rather a highly flexible tool for active social engineering. They argued furiously in the pages of prestigious law reviews that if a legal framework was actively forcing desperate families to commit perjury just to escape abusive or deeply broken homes, then the law itself was fundamentally flawed, practically useless, and morally bankrupt. This was an incredibly dangerous academic proposition. To apply sociological jurisprudence directly to the American family meant that the state, operating through the courts and guided by academic theory, would have to take an active, deeply intrusive role in managing the private lives of its citizens. It meant that elite law professors would have to climb down from their theoretical ivory towers, wade into the uncomfortable muck of human dysfunction, and study the actual real-world outcomes of divorce on women, children, and the broader regional economy. It required a complete and total reinvention of the legal curriculum. The academics suddenly realized they had to figure out how to train an entirely new kind of legal professional. They needed an attorney who was not just a master of contracts and property law, but a sophisticated negotiator, an amateur sociologist, and a financial auditor all combined into one practice. They had to invent the modern family law practitioner from absolute scratch. They began this monumental task by aggressively introducing entirely new disciplines into the isolated law school environment. For the first time in history, legal academics began collaborating with social workers, economists, and early behavioral psychologists. They started publishing exhaustive, data-heavy empirical studies, meticulously documenting the massive societal costs of the fault-based divorce system. They tracked the historical trends of alimony awards, highlighting the disastrous financial potential outcomes for women who were routinely left destitute by rigid legal frameworks. They measured the generational impact of punitive, highly contested child custody battles. Slowly, systematically, over the course of decades, these scholars began to legitimize the study of the family unit within the university. They built a massive, undeniable body of scholarly literature that proved that domestic relations was not a trivial matter of local court drama, but one of the most vital, economically significant, and legally complex areas of American jurisprudence. But writing academic papers and publishing empirical data was simply not enough to change the entrenched machinery of the court system. To truly force a revolution, these radical scholars realized they had to do something completely unprecedented. They had to bring the actual messy, highly emotional reality of the divorce court directly into the sterile theoretical environment of the Ivy League law school. They had to force the most brilliant young legal minds of their generation to stop reading centuries-old appellate decisions and instead sit across a desk from a desperate, impoverished citizen seeking a legal way out of a broken contract. And when the very first major university finally dared to bridge this gap by opening an experimental, on-campus legal clinic dedicated specifically to handling real-world domestic relations cases, it triggered an absolute shockwave of outrage through the conservative legal establishment. The backlash from the old guard was immediate, ferocious, and threatened to destroy the academic careers of everyone involved. The academic establishment was about to go to total war over the right to define and regulate the American family, and the first major battleground was a tiny, controversial experimental clinic that would forever alter the financial trajectory of the legal profession. The year was 1928, and the setting was an institution that prided itself on being the absolute pinnacle of intellectual purity. When a rogue faction of legal realists decided to open a functional legal aid clinic directly affiliated with the university, specifically taking on domestic relations cases, the backlash was nothing short of academic warfare. You have to understand the physical and cultural geography of the elite law school at this time. These were monuments to aristocratic tradition. The sudden influx of distraught, impoverished citizens, weeping in the immaculate marble corridors, carrying the physical and emotional scars of broken households, was viewed by the traditional faculty as a vulgar contamination of the scientific method. The old guard of professors, men who had built their entire careers analyzing the pristine logic of corporate trusts, were entirely appalled. They argued vehemently that the university was a place for theoretical jurisprudence, not a municipal charity ward for marital failures. They accused the clinic founders of dragging the noble profession of law into the gutter, degrading the curriculum by exposing elite students to the sordid, emotional chaos of the lower courts. Imagine if you are a citizen named Margaret living in a major industrial center during the grip of the Great Depression. You are legally bound to a spouse who has abandoned the household, taken whatever meager savings existed, and vanished across state lines. In the traditional legal system of the era, Margaret was an absolute ghost. The prestigious law firms in the city center would not let her past the receptionist. She had no capital, no property to litigate, and therefore, in the eyes of the elite legal establishment, she had no legal problem worth solving. But when Margaret walked through the doors of this newly established university legal clinic, she unwittingly became the catalyst for a total paradigm shift in legal education. The third-year law students assigned to the case, overseen by radical clinical professors, immediately realized that all their rigorous training in classical contract theory was completely useless in the face of Margaret and her daily reality. They could not simply cite an 18th-century English common law precedent to feed her children or sever a marriage to a man who could not be located to be served with traditional papers. The clinic was forced to innovate in real time. These students had to cross academic boundaries that had been strictly forbidden for decades. To solve the case study of Margaret, the law students had to walk across the campus and consult with the sociology department to understand the systemic historical trends of urban abandonment. They had to partner with the nascent School of Social Work to secure emergency housing. They had to analyze the economic realities of female labor force participation to calculate potential support models. For the very first time in American academic history, the law was being treated not as an isolated abstract science, but as an applied interdisciplinary tool for actual human survival. The professors running the clinic meticulously documented every single step of this process. They began compiling exhaustive case files, transforming the tragic, chaotic realities of their clients into rigorous peer-reviewed academic data. They mapped the precise legal bottlenecks, the archaic statutory requirements that forced victims of abuse to hire private investigators just to prove fault, and the systemic financial devastation inflicted upon abandoned spouses. Armed with this undeniable empirical evidence, the clinical professors launched a devastating intellectual counterattack against the traditionalist deans. They published heavily researched papers that systematically dismantled the old, pure legal theories, proving definitively that a legal framework that ignored the social and economic realities of the family unit was practically dysfunctional. They argued that by turning a blind eye to domestic relations, the elite law schools were fundamentally failing in their duty to society. They were producing generations of corporate lawyers who understood how to protect the wealth of a railroad baron, but had absolutely no idea how to protect the fundamental building block of American society, which was the household. This intellectual battle raged throughout the 1930s and 1940s, fundamentally dividing law faculties across the nation. It was a vicious ideological struggle over what the law should be and exactly who the legal system should serve. The most profound impact of these controversial clinics was the slow, undeniable realization of the immense financial and intellectual complexity involved in family law. As the students and professors dug deeper into the mechanics of domestic dissolution, they uncovered a massive labyrinth of intersecting legal disciplines. They realized that dissolving a marriage involved complex tax liabilities, the transfer of real estate, the valuation of closely held family businesses, and intricate estate planning issues. By the time we look back from our current vantage point in 2026, it is incredibly obvious that family law is a highly lucrative, multidisciplinary legal sector with massive potential outcomes for the generational transfer of wealth. But in the mid-20th century, this was a revolutionary academic discovery. The researchers realized that the divorce attorney, long despised as a bottom feeder, actually needed to be one of the most sophisticated, broadly educated practitioners in the entire legal field. They realized that handling a high-stakes divorce required a deep understanding of corporate structure, forensic accounting, and psychological negotiation tactics that went far beyond basic civil procedure. The academic establishment was slowly being forced to concede defeat. The undeniable data pouring out of the legal clinics, combined with the rapidly changing social fabric of post-war America, made it impossible to maintain the old, purely theoretical curriculum. The universities began, reluctantly at first, to integrate domestic relations into their core teachings. They started training a completely new breed of lawyer, one fully equipped to handle the emotional and financial complexities of the modern family unit. But as these newly trained, highly sophisticated lawyers entered the local courtrooms, they immediately slammed into a massive, immovable obstacle. They were armed with advanced interdisciplinary knowledge and a modern understanding of sociology, yet they were still forced to litigate under the deeply corrupt, archaic fault-based laws of the 19th century. The collision between modern legal theory and ancient statutory law was creating an absolutely unsustainable pressure cooker in the American justice system. The system was on the verge of total institutional collapse, and a small group of radical thinkers realized that simply training better lawyers was no longer enough. They had to completely destroy the existing legal framework and rewrite the fundamental contract of American marriage from the ground up, leading to a massive legislative explosion that almost no one saw coming. The academic realization that local court reform was completely impossible under the entrenched fault-based statutes led to a highly strategic and unprecedented pivot in the history of American jurisprudence. Law professors and clinical scholars recognized that continuing to publish peer-reviewed law review articles solely for the consumption of other academics was a futile exercise. They had to step out of the faculty lounges and directly infiltrate the legislative process. They stopped merely analyzing the law and began aggressively lobbying state legislatures. These scholars formed elite, highly influential academic task forces, and their primary ideological target was the very concept of fault itself. They argued relentlessly before legislative committees that assigning moral blame within a failing marriage was an antiquated, deeply religious concept that had absolutely no place in a modern, secular civil contract. The focal point of this intense academic pressure campaign became the state of California in the late 1960s. It is a profound historical irony that the absolute destruction of the traditional American marital contract was ultimately signed into law in 1969 by Governor Ronald Reagan, a conservative political icon who would later admit that passing this specific legislation was one of the greatest political regrets of his entire career. The California Family Law Act of 1969 was not written by grassroots community activists or local politicians. It was meticulously engineered by legal scholars operating out of the most prestigious universities on the West Coast. This legislation introduced a completely alien legal term into the American lexicon, a phrase that is incredibly common to any citizen in the year 2026 but was profoundly radical at the time: irreconcilable differences. Imagine if you were a practicing, highly successful divorce attorney named Robert, operating a lucrative firm in downtown Los Angeles in the year 1968. Your entire business model, your wealth, and your professional reputation relied entirely on navigating the dark arts of the fault-based system. You were an expert at hiring private investigators, staging elaborate and legally binding scenes to prove adultery, and leveraging the immense threat of public scandal to force highly favorable financial settlements for your wealthy clients. You were a master of a very specific, deeply corrupt legal theater. Then, practically overnight, the academic theorists convinced the state legislature to wipe your entire playbook completely off the map. By 1970, under the newly implemented no-fault system, Robert no longer needed a private investigator. He did not need to prove extreme physical cruelty or total marital desertion. If just one single party in the marriage simply declared to the court that the union was irreparably broken, the state was legally obligated to grant the dissolution of the contract. The traditional divorce attorneys across California were thrown into an absolute state of professional chaos. They were forced to completely re-educate themselves on an entirely new statutory framework, while the academic elites watched their grand sociological experiment go live on a massive statewide scale. The immediate historical trend following this legislation was a completely unprecedented explosion in the municipal court dockets. Couples who had been legally trapped for decades in deeply unhappy, dysfunctional, or overtly abusive marriages suddenly possessed a unilateral exit strategy. The regional divorce rate skyrocketed almost immediately, completely validating the long-held academic theory that a massive, invisible pent-up demand for marital dissolution existed, suppressed only by draconian and outdated legislation. But the academic scholars were not satisfied with simply conquering the legal framework of California. They recognized that the American population was becoming increasingly mobile, and leaving a patchwork of different divorce laws across 50 states was a recipe for massive jurisdictional chaos. They wanted to fundamentally rewrite the legal architecture of the entire nation. To accomplish this monumental task, the academic elite utilized a highly powerful, yet historically obscure organization known as the National Conference of Commissioners on Uniform State Laws. This specific governing body was heavily populated by Ivy League law professors, elite appellate judges, and top-tier legal theoreticians. Their stated mission was to draft the Uniform Marriage and Divorce Act, a massive, highly detailed, and thoroughly modern model legal code that could be neatly packaged and exported to every single state legislature in the country for immediate adoption. The academic debates surrounding the drafting of this specific document were absolute intellectual bloodbaths. These scholars were not just deciding the procedural mechanisms of how a marriage legally ends. They were aggressively debating and actively redesigning the entire economic foundation of the American household. The most fiercely contested issue was the future of financial support. If the concept of moral fault was completely removed from the legal equation, how exactly would the state justify the division of property? If a husband was repeatedly unfaithful, destroying the marital trust, should he still be legally entitled to exactly half of the community property or his entire pension? Under the old fault-based system, the innocent spouse utilized the guilty party's moral failure as immense legal leverage to secure massive financial payouts and lifelong alimony. The academics driving the Uniform Marriage and Divorce Act argued successfully that permanent alimony should not function as a lifetime financial reward for good marital behavior, nor should it serve as an economic punishment for bad behavior. Instead, they pushed a radical new economic theory. Alimony should merely be a temporary, rehabilitative measure designed strictly to help the economically dependent spouse transition back into the labor force. This theoretical academic shift from permanent, punitive alimony to temporary, rehabilitative support created massive, completely unintended economic shockwaves that altered the financial trajectory of millions of citizens. The scholars, in their singular pursuit of a clean, mathematically logical, and consistent legal framework, fundamentally miscalculated the brutal systemic economic realities facing older women in the 20th century workforce. Historical trends and economic data from the 1970s and 80s demonstrate a terrifying and immediate spike in the feminization of poverty, directly linked to these new legal frameworks. We can look at countless historical case studies of individuals who had dedicated 30 years of their lives to raising children and supporting a spouse's career progression, suddenly divorced against their will under the new unilateral no-fault laws. These individuals were routinely awarded only 2 or 3 years of rehabilitative support by judges who were strictly following the new academic guidelines, leaving them financially devastated and largely unemployable at a living wage. The universities had successfully sterilized the American divorce process. They had surgically removed the perjury, the staged scandals, and the fabricated courtroom theater. But in doing so, the academics had accidentally removed the only significant financial leverage that the economically weaker party possessed in the negotiation room. The entire legal battleground shifted instantaneously overnight. It was no longer a battle about proving moral failure or marital cruelty. It became entirely about the aggressive, microscopic division of physical assets and future earning potential. The American divorce attorney could no longer operate as a local scandalmonger. They had to rapidly transform into a ruthless financial auditor. The academic establishment suddenly realized they had unleashed a complex economic monster that traditional civil lawyers were completely unequipped to handle, forcing the immediate invention of an entirely new, highly specialized legal weapon that would turn the modern American divorce into a multimillion-dollar forensic war zone. That highly specialized legal weapon was the formal integration of the forensic accountant into the absolute center of the American domestic relations courtroom. When the academic pioneers of the no-fault divorce movement successfully lobbied to remove moral blame from the dissolution process, they inadvertently transformed the courtroom from a theater of human drama into a highly sterile, fiercely contested financial audit. Because the state no longer cared who committed adultery or who was to blame for the collapse of the union, the sole remaining function of the family court was the brutal, microscopic division of physical and abstract assets. The traditional law school curriculum, heavily steeped in 19th-century common law and abstract legal philosophy, was entirely unprepared for this new reality. The academic establishment realized with mounting panic that they were churning out thousands of brilliant young lawyers who could perfectly recite constitutional precedents, but could not read a basic corporate balance sheet, trace a hidden offshore bank account, or calculate the depreciating value of a closely held family manufacturing business. To survive this sudden paradigm shift, the legal academy had to aggressively borrow from an entirely different sector of the university. This era marked the explosive rise of the law and economics movement, a highly influential academic philosophy originating in institutions like the University of Chicago. Scholars within this movement argued that all legal rulings, including those regarding the family unit, should be evaluated strictly through the lens of economic efficiency and wealth maximization. They began publishing massive, deeply complex law review articles that completely redefined the concept of marriage. In the eyes of these new academic theorists, a marriage was no longer viewed as a sacred religious covenant or even a basic sociological unit. It was defined strictly as a joint economic enterprise, a two-person corporate partnership dedicated to the production of household wealth. Therefore, a divorce was simply the liquidation of a corporate entity, and the divorce attorney had to be retrained as an aggressive corporate liquidator. Imagine the standard reality of a high-net-worth individual living in the United States in the current year 2026. Let us call this individual Michael. Michael possesses a deeply diversified portfolio consisting of fluctuating cryptocurrency holdings, restricted stock units from a tech startup, multiple pass-through LLCs used for real estate investments, and a deferred executive compensation package. If Michael's marriage breaks down today, his spouse cannot simply hire a traditional civil litigator and hope for a fair outcome. They must hire a modern divorce attorney who operates less like a traditional lawyer and more like a battlefield commander coordinating a massive strike team of financial specialists. The attorney will immediately deploy forensic accountants to conduct exhaustive lifestyle analyses, tracing every single dollar spent over the last decade to ensure Michael is not funneling marital assets into hidden shell companies. This hyper-complex, multi-million-dollar approach to domestic dissolution is considered standard practice today, but it is the direct, deliberate result of the academic curriculum overhaul that began in the 1980s. During this period, legal academics began heavily researching and designing entirely new legal doctrines to handle the complexities of the modern economy. One of the most fiercely debated academic battlegrounds was the exact legal definition of marital property. The scholars had to answer incredibly difficult, highly abstract economic questions. For example, if a wife works 2 minimum wage jobs for 7 years to entirely fund her husband's Ivy League medical school education, and he files for a no-fault divorce the exact week he receives his highly lucrative medical license, what exactly does she get? Under the rigid, traditional laws of property, she owned half the physical furniture and half the meager bank account. The medical license was just a piece of paper. It could not be sold or traded. But the new wave of legal scholars and economists argued furiously that this was a fundamental market failure. They published groundbreaking papers arguing that the medical degree was, in fact, a marital asset, an intangible human capital investment that represented millions of dollars in future earning potential. This specific academic debate triggered a massive historical trend of profound legal complexity. Universities began offering joint degrees in law and business, recognizing that the modern divorce attorney needed a masterclass in accounting just to survive the discovery process. The courtrooms became bogged down in endless, highly technical wars of attrition. One side's academic economic expert would testify that a family-owned restaurant was worth $5 million based on a capitalization of earnings model. while the opposing spouse's academic expert would testify that the exact same restaurant was completely worthless due to the lack of enterprise goodwill. The divorce attorney was no longer arguing about the character or the moral failing of the human being sitting next to them. They were aggressively cross-examining certified public accountants about tax shelters, depreciation schedules, and the specific discount rates applied to minority shareholder interests in a private holding company. The immediate societal outcome of this academic financialization of divorce was a catastrophic escalation in the sheer cost of legal representation. The system designed by elite academics to be a clean, mathematically logical division of assets required so much expert testimony and forensic tracing that it quickly priced the American middle class entirely out of the justice system. The legal fees required to dissect a 20-year financial partnership could easily bankrupt the very estate the attorneys were hired to divide. The system became a devastating war of economic attrition, where the wealthier spouse could simply starve out the economically dependent spouse by filing endless procedural motions and demanding thousands of pages of obscure financial documentation. The academic dream of a civilized, fault-free separation had mutated into a cold, calculated, and financially ruinous war of spreadsheets. But as the financial parameters of divorce became strictly locked into these rigid, highly technical accounting formulas, a dark and unintended psychological consequence began to emerge. The human beings navigating this system were still experiencing the profound, agonizing emotional trauma of a broken family, but the state had completely removed their ability to air their personal grievances through the fault-based system. The money was locked in a sterile mathematical gridlock. Consequently, the warring spouses, brimming with absolute rage and seeking a new avenue for vengeance, realized there was only one unquantifiable, highly volatile asset left on the board. Since they could no longer publicly litigate who was the worst spouse, they began heavily weaponizing the academic theories of psychology to aggressively litigate who was the worst parent, moving the American legal system toward an incredibly dangerous new frontier. This dangerous new frontier fundamentally transformed the American courtroom from a sterile financial audit into a highly volatile psychological laboratory. To understand the sheer magnitude of this historical shift, we must look at how child custody was managed before the academic revolution of the late 20th century. Historically, the legal system utilized incredibly blunt, simplistic doctrines to determine where children would live after a marriage collapsed. In the 19th century, children were legally considered the strict property of the father, heavily tied to his economic ability to provide. By the early 20th century, the legal pendulum swung entirely in the opposite direction through the adoption of the tender years doctrine, a rigid presumption that young children inherently belonged with their mothers. Both of these historical frameworks were scientifically unnuanced, but they possessed one massive legal advantage: they were absolute. They prevented drawn-out courtroom battles because the outcome was predetermined by the gender of the parent. However, as the academic establishment dismantled the fault-based divorce system in the 1970s and 80s, feminist legal scholars and constitutional law professors simultaneously began to dismantle these gender-based custody presumptions. They successfully argued in prestigious law reviews that assigning custody based strictly on gender violated fundamental equal protection principles. The academic solution to replacing these outdated gender presumptions was the universal adoption of a new, theoretically beautiful, but practically terrifying legal standard known as the best interests of the child. On paper, within the isolated confines of a university library, this standard was a masterpiece of sociological jurisprudence. It demanded that the court ignore the gender of the parents and instead meticulously evaluate the exact developmental, emotional, and psychological needs of the specific child. But the elite legal scholars who drafted this standard failed to anticipate the apocalyptic reality of deploying it within a highly adversarial, hyper-competitive legal system. The best interest standard was an incredibly vague legal vessel. The law provided absolutely no specific metric for what actually constituted a best interest. It simply demanded that the judge figure it out. Because judges are trained in civil procedure and constitutional precedent, not child development or behavioral psychology, they were suddenly forced to rely entirely on outside experts to interpret the new academic standard. This created an immediate multi-million-dollar vacuum in the legal ecosystem, and the behavioral sciences aggressively rushed in to fill it. Imagine a citizen named Sarah navigating a contested divorce in the current year 2026. Under the modern historical trends dictated by this academic shift, Sarah is not merely fighting over a house or a retirement account. She is subjected to a microscopic, grueling psychological audit. Because her former spouse wants primary custody and the financial leverage that comes with it, they have hired an aggressive attorney who immediately petitions the court for a comprehensive forensic custody evaluation. Sarah is suddenly forced to sit in a sterile office and take an MMPI-2, a 567-question diagnostic personality test originally designed to identify severe psychopathology in clinical patients. She is subjected to hours of intense clinical interviews. Her home is physically inspected by a court-appointed psychologist, and her children are interviewed behind closed doors. Her entire personality, her parenting style, and her deepest insecurities are quantified, graded, and compiled into a massive, highly subjective psychological report that will dictate the entire future of her family. The modern divorce attorney, therefore, had to undergo another radical academic evolution. Law schools suddenly realized that teaching tax law and corporate valuation was no longer sufficient. They had to teach law students how to aggressively depose psychiatrists, how to challenge the scientific validity of psychological testing, and how to weaponize the diagnostic and statistical manual of mental disorders. The courtroom became an arena for dueling psychological theories. If a spouse could no longer win by proving moral fault like adultery, they realized they could secure total victory by legally branding the other spouse with a severe personality disorder. Attorneys began meticulously studying academic psychological journals to find new theories they could introduce into evidence. We saw the rise of heavily debated academic constructs like parental alienation syndrome, a theory positing that one parent was systematically brainwashing the child against the other. Whether these specific theories were universally accepted by the broader psychological community or completely dismissed as junk science, they were ruthlessly deployed as tactical legal weapons in the family court system. The financial and emotional toll of this psychological warfare was absolute devastation. The historical case studies of the 1990s and early 2000s are filled with middle-class families who completely liquidated their children's college funds and remortgaged their homes simply to pay the staggering hourly rates of dueling psychological experts. The divorce attorney was trapped in a system that financially rewarded the total psychological destruction of the opposing party. If you wanted to win custody, your legal counsel was practically obligated by their fiduciary duty to portray your former partner as an incompetent, deeply flawed, and psychologically unstable human being on the public record. The system mandated total war, and the children, the exact individuals the academic standard was specifically designed to protect, were consistently caught in the crossfire of these brutal psychiatric cross-examinations. By the late 1990s, a profound sense of institutional horror began to wash over the academic legal establishment. The empirical data returning from the real-world application of the best interest standard was undeniable and catastrophic. Sociologists and developmental psychologists began publishing exhaustive, longitudinal case studies demonstrating the severe, long-term psychological trauma inflicted on children who were forced to testify against their parents or who were subjected to endless psychological evaluations. The Ivy League scholars who had confidently designed this system realized they had made a massive, fundamental miscalculation. They had taken a system designed for resolving objective corporate disputes and forced it to resolve deeply subjective human heartbreak. The adversarial court system, based on the fundamental concept of a winner and a loser, was actively destroying the families it was supposed to regulate. The realization that the courtroom itself was the ultimate poison forced the brightest minds in legal academia to ask an incredibly radical question. If the legal system is actively harming the public, perhaps the ultimate goal of the modern divorce attorney is not to win the trial, but to completely and systematically dismantle the need for a trial to ever take place. This radical proposition marked the absolute genesis of one of the most profound structural shifts in the history of American jurisprudence, a movement entirely engineered by legal scholars who recognized the apocalyptic failure of the adversarial system. The realization that the courtroom was a toxic environment for family restructuring forced the academic establishment to completely abandon centuries of litigation-focused pedagogy and invent an entirely new discipline from scratch. This discipline was alternative dispute resolution, heavily conceptualized by elite academic task forces like the Harvard Negotiation Project. Before this intellectual pivot, law students were strictly trained in positional bargaining, a zero-sum game where every single dollar gained by one spouse was a dollar lost by the other. The new wave of academic theorists argued that this framework was fundamentally pathological when applied to a family unit that would, in reality, have to continue co-parenting for decades after the legal contract was severed. They introduced a revolutionary concept known as interest-based negotiation. The core academic theory posited that if attorneys stopped arguing over rigid legal positions and instead focused on the underlying human interests driving those positions, they could mathematically engineer a mutually beneficial settlement outside the destructive theater of the public courthouse. To understand the sheer mechanics of this academic pivot, imagine a citizen named David living in a major American metropolitan area in the current year 2026. If David enters the traditional family court system, his entire life becomes public record. His financial insecurities, his parenting disputes, and his personal failings are digitized and filed into the municipal database, accessible to anyone with a minimal filing fee. He is subjected to the arbitrary scheduling of an overburdened judge, who might only have 15 minutes to review a heavily complex 50-page financial affidavit before rendering a life-altering decision. However, because of the massive academic reformations of the late 1990s, David now has access to a completely parallel, highly privatized justice system. His modern divorce attorney will likely steer him away from the courthouse entirely and into a practice known as collaborative law. The structural mechanics of a collaborative divorce are a direct manifestation of advanced academic legal theory. When David and his spouse agree to this process, their respective attorneys sign a highly binding, incredibly dangerous legal contract known as a disqualification agreement. This document explicitly states that if the negotiations break down and either party decides to file a motion in public court, both attorneys are immediately and legally fired. They cannot represent their clients in litigation. This creates a massive, mutually assured destruction scenario that radically alters the psychological incentive structure of the modern divorce attorney. For the first time in legal history, the attorney's financial survival and professional mandate are permanently severed from the act of warfare and inextricably linked to the act of peacemaking. They are no longer gladiators. They are highly specialized diplomats operating under the intense pressure of a ticking clock. This required another massive overhaul of the American law school curriculum. Traditional litigation clinics, where students practice cross-examining hostile witnesses, were suddenly operating alongside newly funded mediation and dispute resolution clinics. The academic establishment realized they had to retrain the fundamental psychology of the legal practitioner. A lawyer trained to aggressively object, to interrupt, and to demolish the credibility of an opposing party is actively detrimental in a mediation setting. Law schools began bringing in clinical psychologists to teach law students the advanced mechanics of active listening, emotional de-escalation, and the identification of hidden cognitive biases that prevent warring spouses from reaching a settlement. The modern divorce attorney had to become a master of the caucus, the highly strategic practice of separating the spouses into different rooms and systematically defusing their emotional volatility, while simultaneously crunching complex actuarial tables to find a mathematically viable path forward. Furthermore, the academic scholars realized that lawyers, even those trained in advanced negotiation, were still fundamentally unequipped to handle the deep emotional and financial nuances of a dissolving household on their own. They engineered the modern collaborative divorce not as a solo legal practice, but as a multidisciplinary task force. In our 2026 scenario, David's legal team does not just consist of an attorney. The standard academic model now dictates the inclusion of a neutral financial professional to transparently map the division of assets without adversarial bias, and a licensed mental health professional acting as a divorce coach to actively manage the psychological trauma of the transition. The divorce attorney was transformed from a solitary courtroom warrior into the project manager of a highly specialized corporate restructuring team. While this academic framework sounds like a utopian solution to the horrors of the traditional family court, empirical sociologists rapidly identified a massive, highly concerning historical trend resulting from this shift. By pulling the most complex, high-net-worth divorces out of the public courthouse and into the private conference rooms of elite collaborative attorneys, the academic establishment inadvertently created a deeply entrenched two-tiered system of American justice. This is the phenomenon of private judging and shadow courts. Wealthy citizens like David could completely buy their way out of the broken, underfunded municipal court system. They could rent retired appellate judges at staggering hourly rates to adjudicate their disputes in total privacy, utilizing the academic frameworks of mediation and collaborative law to shield their wealth and their personal failures from the public eye. Meanwhile, the middle and lower classes, who could not afford the massive retainer fees required to hire a multidisciplinary collaborative task force, were left completely abandoned in the crumbling infrastructure of the public family courts. The public system became a dystopian landscape of pro-se litigants, individuals forced to represent themselves because the cost of even a basic, traditional divorce attorney had skyrocketed beyond the reach of the average American household. The academic elite had successfully solved the problem of divorce, but they had only solved it for the top 10% of the economic strata. By privatizing the most lucrative sectors of family law, the legal academy had unwittingly set the stage for a massive crisis of accessibility. The legal system was practically begging for a disruptive force to shatter the monopoly of the expensive, highly credentialed divorce attorney and deliver affordable legal access to the desperate masses. And just as the legal scholars believed they had perfected the architecture of the modern family practice, an entirely unseen, deeply disruptive force began silently emerging from the computer science departments of those exact same universities, a force that threatened to render the human divorce attorney completely obsolete. That deeply disruptive force was the birth of computational law, a radical new academic discipline forged in the highly experimental, heavily funded laboratories where the university computer science departments officially merged with the law schools. By the early 2000s, empirical researchers across the American academic landscape had compiled terrifying historical trends regarding the access to justice gap. Their data proved definitively that the hypercomplex, heavily financialized family law system they had spent decades designing was now completely inaccessible to roughly 80% of the American public. The traditional divorce attorney had simply become too expensive for the working class to hire. Seeing this massive systemic failure, a new generation of academic engineers and legal theorists hypothesized that if the modern divorce was essentially just a complex financial audit driven by specific statutory formulas, then there was absolutely no logical reason a human being needed to do the math. They believed they could translate the entire legal ontology of American domestic relations into cold, objective, highly efficient computer code. This required a monumental academic undertaking. Researchers began scraping the municipal databases of family courts across the country, compiling millions of digitized divorce decrees, marital settlement agreements, and judicial rulings. They fed this massive ocean of legal data into early machine learning algorithms, teaching the software to recognize exactly how human judges distributed assets, calculated spousal support, and resolved debt allocation in thousands of different financial scenarios. What these academics discovered was highly threatening to the traditional legal establishment. They found that despite the immense hourly rates charged by human lawyers, the vast majority of divorce outcomes were incredibly predictable. If you knew the length of the marriage, the gross incomes of both parties, and the jurisdictional zip code, the algorithm could predict the final financial settlement with terrifying accuracy. The academics realized that for most middle-class families, the human divorce attorney was functioning as nothing more than a highly glorified, incredibly expensive data entry clerk, acting as an unnecessary toll booth on the road to a mathematically predetermined outcome. Imagine a citizen named Thomas navigating the dissolution of his marriage in the current year 2026. Thomas and his spouse are middle-class wage earners living in a suburban district. They possess a joint mortgage, 2 retirement accounts, a modest stock portfolio, and accumulated credit card debt. 10 years ago, they would have been forced to hire 2 separate human attorneys, paying tens of thousands of dollars in retainer fees just to argue over how to split these assets. But in 2026, Thomas bypasses the traditional law firm entirely. He logs onto an algorithmic dispute resolution platform, a system directly descended from those early university computational law clinics. He does not speak to a human. Instead, the software prompts him to securely link his financial architecture directly to the platform via encrypted application programming interfaces. Within seconds, the algorithm ingests his bank statements, verifies his mortgage payoff amount, calculates the real-time vested value of his retirement accounts, and analyzes 5 years of joint tax returns. It applies the specific equitable distribution statutes of his exact state, factoring in the historical trends of how local judges have ruled on similar debt-to-asset ratios. Within exactly 45 minutes, the platform generates a comprehensive, legally binding marital settlement agreement. It presents Thomas and his spouse with 3 distinct potential outcomes for asset division, calculating the precise, long-term tax liabilities of each highly optimized scenario. It drafts the qualified domestic relations orders required to legally split the retirement funds without triggering federal tax penalties, a highly specialized task that a human attorney would traditionally charge thousands of dollars to complete. The software performs this entire process flawlessly, without a single mathematical error, for a flat fee of $299. Thomas and his spouse digitally sign the algorithmically generated contract, the The software automatically e-files the documents with the county clerk, and the marriage is dissolved. The human divorce attorney has been completely eradicated from the transaction. When these automated platforms first began to aggressively capture the middle-class legal market, the academic and professional backlash from the traditional legal establishment was absolute warfare. Law professors who had spent their entire careers teaching the nuances of human negotiation watched in horror as computer scientists completely bypassed their curriculum. The American Bar Association and state-level unauthorized practice of law committees, organizations historically operated by human lawyers to protect their professional monopoly, launched massive legal strikes against these tech companies. They argued vehemently that software algorithms could not possess a fiduciary duty, that code could not provide ethical counsel, and that allowing a machine to sever a legal contract of marriage was a profound degradation of the justice system. The universities became the ground zero for a vicious philosophical civil war. The computer scientists argued they were democratizing the law and saving families from financial ruin, while the traditional legal ethicists argued they were unleashing a dangerous, unregulated black box onto the American public. The ethical scholars published deeply critical case studies focusing on the catastrophic potential outcomes of algorithmic bias. They pointed out a glaring flaw in the machine learning process. If the artificial intelligence was trained on decades of historical court records, and those historical court records were deeply infected by the unconscious gender, racial and socioeconomic biases of 20th century human judges, then the algorithm was not actually objective. It was simply automating and scaling human prejudice at the speed of light. If a predictive algorithm consistently recommended lower alimony payouts for minority women, because that is what the historical data reflected, the machine was actively enforcing a discriminatory feedback loop under the false guise of mathematical neutrality. The academic debate raged over whether it was even possible to code human empathy, ethical nuance, and contextual mercy into a silicon processor. Despite the fierce ethical protests, the sheer economic efficiency of the software was completely undeniable. The algorithmic platforms continued to evolve, entirely swallowing the uncontested divorce market and fundamentally threatening the financial survival of thousands of solo legal practitioners. The human divorce attorney was suddenly forced to pivot once again, desperately trying to justify their massive hourly rates to a public that now had access to instantaneous, mathematically perfect legal algorithms. The lawyers retreated to the only territory the machines could not yet conquer: the hyper-complex, high-net-worth cases involving offshore trusts, hidden assets, and deep corporate litigation. But the computer scientists in the academic labs were not stopping at simple asset division. Having successfully automated the financial destruction of the marital contract, these researchers turned their attention to the final, most terrifying frontier of family law. They began writing incredibly complex code designed to replace the judge, the psychologist, and the human attorney in the single most volatile, emotionally devastating arena of human existence, setting the stage for a technological intervention in child custody that would challenge the very definition of what it means to be a parent. The attempt to translate the deeply subjective, emotionally volatile concept of the best interests of the child into cold, executable computer code represented the most ambitious and ethically dangerous academic experiment in the history of American jurisprudence. While algorithms had easily conquered the mathematical division of bank accounts and real estate, human parenting was not a ledger of fixed assets. It was an incredibly complex biological and sociological dynamic. Yet, by the early 2020s, elite university consortiums bridging the gap between computational data science and developmental psychology began publishing heavily funded research papers claiming they had solved the unquantifiable. These academic researchers argued that human judges and court-appointed forensic psychologists were fundamentally flawed instruments for determining custody. Human evaluators suffered from fatigue, implicit biases, and an inability to process massive datasets. The academics proposed that a sufficiently advanced neural network, trained on millions of historical custody outcomes and longitudinal psychological studies, could predict a statistically optimal parenting plan with far greater accuracy and significantly less emotional collateral damage than the traditional adversarial court system. Imagine a citizen named Jessica living in a rapidly expanding American tech hub in the current year 2026. Jessica and her former partner are entering a highly contested custody dispute over their two young children. 10 years ago, their respective divorce attorneys would have initiated a brutal war of psychological attrition, hiring competing mental health professionals to conduct exhaustive, highly subjective personality tests and home evaluations. In the reality of 2026, the landscape of domestic litigation has been radically terraformed by academic innovation. Jessica is not evaluated by a human being with a notepad. Instead, a judge orders both parents to submit to a comprehensive algorithmic behavioral audit, a digital evaluation framework designed by top-tier legal and technological scholars. This system operates by ingesting an absolutely staggering amount of objective, verifiable data to calculate a highly complex parental stability index. The machine learning model utilized in Jessica's case does not ask her how she feels about her children. It actively measures her historical behavior through the digital footprint she has left behind over the past decade. The algorithm securely interfaces with her smartphone to analyze geolocation data, mathematically verifying exactly who performed the school drop-offs, who attended the pediatric dental appointments, and who spent more physical time in the family home during the evenings. It deploys advanced natural language processing to scan 5 years of text messages and emails between the parents, conducting a microscopic sentiment analysis to quantify the exact frequency of hostile communication, emotional volatility, and cooperative co-parenting efforts. It reviews financial histories not just for asset division, but to calculate economic stability and responsible spending patterns as a metric of overall household security. Every single interaction, every digital transaction, and every geolocated movement is fed into the black box, which cross-references Jessica's specific data against millions of historical case studies to predict potential outcomes regarding the future psychological welfare of her children. This technological intervention completely shattered the traditional role of the American divorce attorney. The academic institutions realized they were no longer preparing law students to cross-examine human psychologists on the witness stand. The modern attorney suddenly had to learn how to aggressively litigate the parameters of a machine learning model. If the algorithmic platform generated a parenting plan that awarded Jessica only 30% custody based on a predictive risk score, her attorney could not simply argue that she was a good mother. Her attorney had to become a hybrid legal and technical auditor. The courtroom battles of the mid-2020s shifted from arguments over human character to brutal, highly technical disputes over data privacy, algorithmic training weights, and the admissibility of machine-generated behavioral analytics. Divorce attorneys had to hire expensive computer scientists to analyze the source code of the court-mandated algorithms, searching for historical biases baked into the system by the original academic programmers. Historical trends leading up to this exact moment demonstrate a profound crisis of legal legitimacy. Sociologists warned that by automating the custody process, the legal system was stripping away the fundamental human element of mercy and contextual understanding from family law. They presented alarming case studies where perfectly capable, loving parents were penalized by the algorithm simply because their highly demanding work schedules triggered an automated instability flag, or because their regional dialect was misinterpreted by the natural language processing software as inherently aggressive. The academic debate reached a boiling point over the concept of algorithmic determinism. The ethical scholars argued furiously that a predictive model, no matter how sophisticated, was punishing parents for statistical probabilities rather than actual misconduct. The machine was fundamentally incapable of understanding human redemption, personal growth, or the nuanced reality that a flawed human being can still be a deeply loving and necessary presence in a child's life. Yet, despite the intense ethical outrage from traditional legal purists, the empirical data supporting these automated systems was incredibly difficult for the academic establishment to ignore. Proponents of the algorithmic custody evaluations published massive studies demonstrating that the software was actively reducing the catastrophic financial costs of divorce and dramatically accelerating the timeline of dispute resolution. By removing the highly paid human experts and the endless months of adversarial posturing, the algorithms were saving American families millions of dollars and shielding children from prolonged exposure to the toxic environment of the public courthouse. The system was undeniably cold, mathematically ruthless, and terrifyingly intrusive, but according to the raw data, it was functionally superior to the broken, deeply flawed human legal machinery it was replacing. The divorce attorney was backed into a definitive historical corner. For over a century, they had survived massive academic paradigm shifts by adapting to new legal environments. They had transitioned from orchestrating staged infidelities in the fault-based era to navigating the highly complex financial webs of the no-fault revolution. They had evolved from aggressive trial litigators into sophisticated collaborative negotiators. But the rise of computational law and algorithmic adjudication represented an entirely different type of existential threat. The artificial intelligence was not just changing the rules of the game. It was systematically removing the need for human players on the board. The academic institutions that had birthed the modern divorce attorney were now actively building the exact technological infrastructure designed to render them obsolete. As the legal establishment stared down this unprecedented technological singularity, a final, desperate strategy began to formulate within the most elite law firms in the country, a highly controversial approach that would attempt to merge the ancient art of legal counsel with the unstoppable force of artificial intelligence, leading to an absolute climax in the evolutionary timeline of the legal profession. The response from the elite legal establishment to this existential technological threat was not a retreat, but a highly calculated, heavily funded assimilation. The most prestigious law schools and the most powerful family law firms across the United States realized that fighting the algorithmic revolution was a futile endeavor. Instead of attempting to ban the artificial intelligence, they decided to merge with it, creating a terrifyingly efficient, highly lucrative hybrid model of practice. This marked the birth of the augmented divorce attorney. The academic institutions that had inadvertently created the technology that threatened to destroy the legal profession now offered the ultimate, high-priced solution. Elite universities began offering highly specialized, interdisciplinary postgraduate degrees that combined advanced jurisprudence with complex machine learning and data architecture. The traditional law school curriculum was terraformed yet again. Courses on basic legal research and standard civil procedure were completely stripped down and replaced by intense seminars on legal prompt engineering, algorithmic bias auditing, and cryptographic asset tracing. Imagine a citizen named Emily living in the current year 2026. Emily is entangled in a massive high-net-worth domestic dissolution. Her spouse is a sophisticated venture capitalist who has spent the last 5 years aggressively and intentionally obfuscating marital wealth through a labyrinth of decentralized autonomous organizations, offshore shell companies, and anonymous cryptocurrency wallets. If Emily were to rely on the automated, low-cost algorithmic platforms designed for the middle class, she would be completely financially decimated. Those standard algorithms rely on transparent data inputs and standard banking interfaces. They are fundamentally incapable of recognizing intentional human deception. To survive this highly predatory financial environment, Emily must hire an augmented divorce attorney, a practitioner who operates at the absolute bleeding edge of academic legal theory and technological capability. When Emily walks into this modern law firm, she is not paying for a human being to read through thousands of pages of financial disclosures. That era of the legal profession is completely dead. The augmented attorney commands a proprietary, hyper-advanced neural network specifically trained to hunt hidden assets. The attorney feeds the artificial intelligence every single scrap of data connected to Emily and her spouse. Within a matter of seconds, the machine learning model cross-references decades of global financial transaction patterns, analyzing metadata from server logs, tracing the blockchain ledgers of thousands of decentralized transactions, and identifying highly complex, mathematically anomalous patterns that a team of human forensic accountants would take 5 years and millions of dollars to discover. The algorithm acts as an incredibly powerful, microscopic spotlight, illuminating the exact coordinates of the hidden marital wealth. But the algorithm cannot walk into a courtroom, it cannot depose a hostile witness, and it cannot negotiate a deeply emotional settlement with a furious spouse. This is where the human divorce attorney reasserts their absolute dominance. The lawyer has evolved from a brute force data processor into a high-level strategic commander. Emily relies on her attorney to take the raw, cold data generated by the artificial intelligence and translate it into a devastating legal narrative. The human attorney uses their deeply refined emotional intelligence, a skill entirely cultivated through the academic study of sociology and behavioral psychology, to read the room during a high-stakes mediation. They understand the precise moment to leverage the AI-discovered financial anomalies to force a favorable settlement, and they know exactly how to manage Emily's own psychological trauma throughout the grueling process. The augmented attorney provides the contextual wisdom, the ethical judgment, and the profound human empathy that a silicone processor fundamentally lacks. This synthesis of human strategy and artificial intelligence triggered a massive historical trend that completely shattered the economic foundation of the American legal profession: the absolute death of the billable hour. For over a century, the economic power of the divorce attorney was entirely derived from billing clients in 6-minute increments for the grueling manual labor of legal research and document drafting. But when an artificial intelligence can draft a perfectly customized, legally binding 50-page marital settlement agreement in less than 3 seconds, the traditional billing model becomes practically fraudulent. academic economists and legal scholars had to completely redesign how a law firm monetizes its services. We saw a rapid industry-wide pivot toward value-based billing, flat-fee portfolio management, and algorithmic subscription models. The modern divorce attorney is no longer compensated for their time. They are compensated strictly for their strategic access to proprietary technology and their ability to successfully pilot that technology to secure optimal potential outcomes for their clients. As we look back upon the entire sweeping historical arc of the divorce attorney in American academia, the transformation is almost entirely unrecognizable. We began in the suffocating traditionalist lecture halls of 1895, where the academic elite viewed the dissolution of the family unit as a sordid, morally compromised topic entirely unworthy of scientific study. We watched as a rogue faction of legal realists and clinical pioneers dragged the actual messy reality of human suffering into the ivory tower, forcing the universities to acknowledge the profound socio-economic importance of the household. We analyzed the catastrophic, unintended consequences of the no-fault revolution, where scholars attempted to mathematically sterilize the emotional chaos of separation, only to turn the courtroom into a brutal, multi-million-dollar forensic war zone. We witnessed the rise of psychological warfare under the best interest standard, and the subsequent desperate academic attempt to privatize the entire system through collaborative law and mediation. Ultimately, this historical study reveals a profound and continuous paradox at the very heart of American jurisprudence. For over 130 years, the brightest minds in legal academia have continuously attempted to design a flawless, scientifically perfect system to manage the death of the American family. They have utilized sociology, economics, behavioral psychology, and now artificial intelligence in a relentless pursuit to codify, regulate, and optimize human heartbreak. Yet, every single time the academic establishment deployed a new theoretical framework to solve the crisis of the family court, they inadvertently created an entirely new, significantly more complex, and vastly more expensive legal monster. The divorce attorney was forced to continuously mutate, evolving from a despised purveyor of staged perjury into the most sophisticated, multidisciplinary, technologically augmented legal practitioner on the face of the earth. The academic crusade to minimize the divorce attorney ultimately resulted in their absolute ascension to the pinnacle of legal power. The integration of artificial intelligence into the practice of family law seems to represent the absolute climax of this evolutionary timeline. The elite human attorney, armed with algorithmic omniscience, appears to have finally mastered the system. They have seemingly achieved the perfect balance of technological efficiency and human empathy. But the relentless engine of academic innovation never actually stops. While the legal establishment celebrates the triumph of the augmented attorney, a highly secretive, deeply controversial faction of computational sociologists and behavioral economists are currently drafting the blueprints for a system that will make the 2026 model look entirely obsolete. They are compiling historical data not just to resolve a broken marriage, but to mathematically predict the exact moment a marriage will fail before the spouses even realize it themselves. We must now turn our attention to the terrifying, highly classified academic research into predictive domestic policing and the algorithmic pre-crime of the marital contract, because the state is no longer satisfied with simply managing your divorce, it is preparing to mathematically intervene before you ever file the paperwork.